This Honourable House now resumes its sitting. Call of the roll.
Mrs. Holness, Mr. Bartlett, Mr. Holness, Dr. Clark, Dr. Chang, Mr. Shaw, Mr. Samuda, Ms. Grange, Mrs. Williams, Mrs. Malawi Ford, Dr. Tufton, Mr. Mackenzie, Mr. Chuck, Mr. Vaz, Mr. Warmington, Mr. Charles, Mr. Green, Mr. Morgan, Mr. Hutchinson, Mr. Terry Long, Ms. Smith, Dr. Dunn, Mrs. Cuthbert Flynn, Mr. Main, Mr. Davis, Mr. Witter, Mr. Brown, Dr. Brown-Burke, Dr. Charles, Mr. Chin, Mr. Clark, Mr. Cousins, Ms. Crawford, Ms. Daly, Ms. Davis, Mr. Golding, Mr. Graham, Dr. Guy, Ms. Hamilton, Ms. Hannah, Mr. Henriquez, Mr. Henry, Mr. Hilton, Mr. Jackson, Mr. Lawrence, Ms. Lee, Mr. Miller, Mr. Montague, Ms. Morrison, Mrs. Nita Garvey, Mr. Paulwell, Mr. Phillips, Dr. Phillips, Mr. Robertson, Mr. Robinson, Mr. Siblist, Mr. Slowly, Mrs. Vaz, Dr. Wheatley, Mr. Williams, Mr. Wilson, Mr. Wright, Mrs. Nita Garvey,
Members, as usual, it is our honor and pleasure to welcome all of you sitting here and those in the public domain welcome you to the continuation of the sectoral debate, where this afternoon the Minister of Legal and Constitutional Affairs, Mrs. Marlene Malahoo Fort, will make her presentation to this House. I also want to extend a special welcome to those joining us online via YouTube, on PBC TV, and those who are with us in the gallery today to support the Minister as she presents in the sectoral debate. We welcome you all and trust this will be an informative and good sitting of the House. Statements by Ministers.
Madam Speaker, there are no formal statements. To continue on the point you made with regards to the business of today, I would indicate also that we will move straight into the continuation of the sectoral debate and to have a recommittal of the items in between, after, so as to facilitate the completion of the agenda. May it please you, Madam Speaker.
Members, the question before the House is that we have a suspension of the items listed on the agenda paper today and go straight to the continuation of the sectoral debate, after which we will have a recommittal of the items. Those in favour? Those against? The ayes have it.
Madam Speaker, in the context, therefore, of the House having agreed on this resolution, I invite you to ask the member for St. James West Central and newly minted Minister of Legal and Constitutional Affairs to address this Honourable House. May it please the Madam Speaker.
I join with us all in welcoming the newly minted, as the House Leader said, Minister of Constitutional and Legal Affairs, to make her presentation to this House. Mrs. Marlene Malaford.
Madam Speaker, although this is my 7th consecutive contribution to these sectoral debates, it is my maiden as Minister. My deep gratitude for the Prime Minister's vote of confidence, which elevated me to his cabinet with full portfolio responsibility, takes second place to the commendation I must pay him for the bold step he took to establish this Ministry of Legal and Constitutional Affairs, to bring unprecedented, focused attention to the government's legislative and constitutional reform aspirations. It is no secret, Madam Speaker, that I have a sacred passion for the law and an abiding interest in the subjects of the portfolio, even though, of course, I'm always prepared to serve wherever I best add value to my team. All of us who serve the public, especially from elected political offices, bank on the support and kind understanding of our constituents, colleagues, friends and families. Because, Madam Speaker, I think it's no exaggeration to say that life in representational politics is hellacious. As such, I acknowledge
members, just
gratitude.
a moment. Members, there's a heavy murmur, and the Minister is making her presentation, and I really think out of courtesy, we should allow her to be heard. Please.
Thank you, Madam Minister. As I was saying, all of us who serve the public, especially from elected political office, bank on the support and kind understanding of our constituents, colleagues, friends and families, because it is no exaggeration to say that life in representational politics is hellacious. Yeah. As such, I acknowledge with profound gratitude the many, especially my family and close circle of friends, who have helped and held me along the way, who have stood and continue to stand in the gap with me. Although it is not possible in the context of this presentation to name them all, you will understand if I single out my husband, the Honourable Justice Ian Ford. Madam Speaker, I cannot thank him enough for his love, support and wise counsel. May he always know how much I truly love, admire and respect him. I should also like to once again place on record my thanks to the team at the Attorney General's chambers and to wish my successor in the Office of Attorney General, Dr. Derek McCoy, Queen's Counsel, a satisfying tenure. I remain grateful for the cooperation and support of the CADOF professional, civil and public servants, fellow parliamentarians on both sides of the aisles, the parliamentary staff and the ministers of government, in particular, the Honourable Dr. Horace Chang, Deputy Prime Minister and Minister of National Security, and the Honourable Delroy Chuck, Minister of Justice, with whom I continue to work closely and have always enjoyed a collegial relationship. Very special thanks, Madam Speaker, to my Secretary, Personal Assistant, Mr. Desmond A. Smith, and the close protection officers assigned to me, Corporal Shard Walters and Constable Edwin Kalu Jr., who often go beyond the call of duty. Madam Speaker, permit me to use this occasion to pay homage to my St. James West Central constituents as their duly elected representative in this Honourable House. I should also like to acknowledge my office staff, including the CDF officer, Mr. Gregory Brissett, Constituency Secretary, Ms. Ava Gordon, Divisional Secretary, Ms. Angela Braham, the groundsman, Mr. Dwight Livingston, and the executive and management teams, including Councillor Dwight Crawford of the Spring Garden Division, Divisional Chair and Coordinator, Mrs. Rena Forbes, and Mr. Brian Hosu of the Mount Salem and Granville Divisions. And Madam Speaker, all the members of my management team, Messieurs Robin and Robert Russell, Dale Della Pena, Neil Baugh, and Miss Anne-Marie Tree. And Madam Speaker, I warmly greet all who are tuned in, watching and listening attentively to this address, including Councillor Troop and Councillor Kerry. Madam Speaker, our constituents are depending on us. Our constituents are depending on us to do right by them. Many have no privilege of office or any connection in high places. They need every part of government with which they interact to be more responsive, more efficient, and more accountable to them. We must therefore be relentless in our representation to have a strong and effective government to better serve them. Because, Madam Speaker, a weak and ineffective government is easily manipulated to produce unjust and corrupt outcomes that harm the people. Doing right by the people includes exercising greater care in how we manage campaigns when running for office. So often, we give the impression that we can do all things to all men and end up relieving others of their share of responsibility for the work. Unrealistic expectations are set, which cannot be met, leading to disappointment and distrust. Furthermore, we make the grave mistake of thinking that it is okay to engage in the most despicable acts and illicit activities on the campaign trail, but then expect integrity in the affairs of government when those who so engaged are put in charge of any part of government. My generation of political leaders must consciously eschew the evil practices done in the name of partisan politics, and then deliberately practice politics in a more constructive and indubitable manner. Madam Speaker, I take responsibility. I take the responsibility of my constituents very seriously, and I believe all of us do. My style of politics is not the up-in-your-face, rambunctious style. Not that anything is wrong with that. My preference is to, without fanfare, go about the business of the people, spending time to get first-hand knowledge on what is happening on the ground, and speaking with constituents directly. Madam Speaker, it truly irks me when I make the necessary representation to have issues addressed, and then the appropriate part of government with responsibility is unresponsive or delivers substandardly. We desperately need all parts of government to work together, with each part doing its fair share of the work. What happens in one part impacts what happens in other parts. While the MP is often the first point of contact with government for many constituents, it is vitally important that they understand that government is much bigger than the political directorate. Yes. The belief that the MP has the power and authority to take action to fix whatever is wrong in government is a mistaken one. Because government, Madam Speaker, is not a one-man show. The ministries, departments, and agencies are staffed by administrative, professional, technical, and other officials. We sometimes forget that although the boundary lines between the political directorate on the one hand and the civil and public service on the other hand sometimes blur, they are in fact sharply drawn in many areas. Madam Speaker, I have always maintained that the face of government that we see at any given time is the face of the individual or the institution we interact with. In our quest for improved governance, the relevant office holders whose conduct is in question is to be held to account. Roles and functions are formally and legally assigned to various offices across government. It cannot be overemphasized that the place, the spot of fault is where it occurs. I said it last year and I'm repeating it this year. The persistent failure to hold individuals to account or to do so in a timely manner, and the tendency to broad brush an entire cohort have tarnished individuals, have tarnished institutions, and have compromised systems. Madam Speaker, the complex legal and political governance issues I deal with on a daily basis expose the underbelly of the society and bring the inner workings of government into sharp focus. How Jamaica responded to the COVID-19 pandemic, for example, can be a most useful case study. While addressing these complex legal and political governance issues, have served to deepen my working knowledge of all areas of the law, especially constitutional and administrative law. They have also highlighted things taken for granted by state agents in the performance of duties and the general exercise of leadership at various levels. These things not only expose the state to liability, but they also undermine confidence in the machinery of government and decrease government's effectiveness. Madam Speaker, on the matter of constitutional law, I must mention in passing how I welcome the clarity provided by the Judicial Committee of the Privy Council on the vexed question of mandatory minimum sentences and on the separation of powers doctrine in its judgment given on 16 May 2022 in the case of J. Chandler, and the state Trinidad and Tobago. The principal constitutional question raised in that appeal was whether the mandatory death penalty for murder was contrary to the Constitution of Trinidad and Tobago, adopted in 1976 when the state became a republic. In reiterating the law applicable to constitutions on the Westminster model, at paragraph 79 of the judgment, the following appears. Turning to the role of the legislature, Lord Diplock stated in Hines against the Queen, that's a case out of Jamaica, in the exercise of legislative power, Parliament may, if it thinks fit, prescribes a fixed punishment to be inflicted on all offenders found guilty of a defined offence, as, for example, capital punishment for the crime of murder, or it may prescribe a range of punishments up to a maximum in severity, either with or without a minimum, leaving it to the court by which the individual is tried to determine what punishment falling within the range prescribed by Parliament is appropriate in the particular circumstances of the case. Madam Speaker, I highlight this because the issue of the mandatory minimum penalty, which we have provided for in the new firearms law, has been the subject of very heated debate in the Parliament, understandably so. And many have argued, questioned the constitutionality of the provision. And lo and behold, before we have even passed the law, our final court has reminded that it is indeed quite permissible. And of much more significance for me, Madam Speaker, our final court, in the same Chandler case, reminded that the separation of powers also works to prevent judges from arrogating to themselves powers vested in another branch of government. You know, sometimes we think about it as the Parliament or the executive intruding on the legislature, but a poignant reminder that it also appears to the judicial branch. Madam Speaker, my almost 6 years tenure as Attorney General, atop my role as Member of Parliament, gave me new insights into how the law impacts the everyday life of the people. Early in the day, I began to closely examine the relationship between the rule of law and sustainable development, from the perspective of the law as a development end, as well as a means to sustainable development. Over the years, I've also been analyzing this relationship through the lens of the three rule of law components: legal frameworks, institutional capacity, and legal empowerment. In developing legal frameworks, great care is required at each stage of the process. The spirit of the law, as well as the letter of the law, must be clear to avoid unintended consequences in use and interpretation of the law. Madam Speaker, permit me to now direct attention to the portfolio work of the ministry. I gather there is much anticipation across government and in the wider society, as well as in the diaspora, of what I may be announcing on the constitutional reform front. If I had the skills of some who presented before me, I would cut a tune. But, you know, I know my limitations. No. I will do what I can a little later on. I'll do what I can a little later on. But let me just tell you, Zion train is coming our way.
All right.
Zion train is coming our way. Get on board. Get on board, because Zion train is coming our way. Okay. Metaphorically speaking, of course. Before dealing with the matter of constitutional reform, I will first report on the work done in the other portfolio areas of the ministry for the reporting period. In doing so, I should like to firstly acknowledge my permanent secretary, Mr. Wayne O. Robertson, who is here in the House, Madam Speaker. P.S. Robertson has been working assiduously to set up the ministry. I have to say a big thank you to the Office of the Prime Minister, where we are currently housed, and the Ministry of Justice, with whom we share corporate services. I second what the Prime Minister said when he acknowledged Permanent Secretary Mrs. Audrey Sewell of the Office of the Prime Minister and the Ministry of Economic Growth and Job Creation as one of the most effective, knowledgeable and hardworking permanent secretaries. Mrs. Sewell has been very helpful to us, and I know that Mr. Robertson has learned much from her. My every interaction with her has been pleasant, professional and productive. Madam Speaker, in my maiden ministerial statement to this Honourable House on January 18, a week after this ministry was created, I advised that the portfolio has been assigned 4 subjects and 3 departments for a start. The subjects are legal reform, constitutional reform, legal education, which includes the Council of Legal Education's Norman Manley Law School, now under the principalship of Ms. Carol Aino. And fourthly, the protection of human rights, which involves interfacing with the Office of the Public Defender. The departments are the Office of the Parliamentary Counsel, headed by the Chief Parliamentary Counsel, Ms. Judith Grant, the Legal Reform Department, headed by Ms. Nadine Wilkins, and the Law Reform Secretariat, headed by Mrs. Julia Gowie Williams. Madam Speaker, I use this occasion to thank the outgoing Public Defender, Mrs. Arlene Harrison Henry, for her service as head of this important commission of Parliament, and to also commend the staff of the office for their work on behalf of the people of Jamaica. I will address the outstanding matter of the proposed National Human Rights Institute at a later date. I now turn to the Norman Manley Law School. From the time of my appointment as the Attorney General in 2016 until I demitted that office in January of this year, I served as a member of the Council of Legal Education, pursuant to the provisions of the Council of Legal Education Act, which provides for the agreement establishing the Council of Legal Education to have the force of law in Jamaica, and which, among other things, mandates the Attorney General's membership on Council. Madam Speaker, I got a first-hand understanding of the operations of the Council and learned that I was an exception to my predecessors in office based on my regular attendance at Council meetings and my participation in its various other activities. Now, as the Minister for the time being charged with the responsibility of legal education, I'm pleased to continue my relationship with the Council of Legal Education, albeit in a different capacity. And I'm also pleased to provide a brief report on the Norman Manley Law School, which is located on the Mona campus of the University of the West Indies here in Jamaica. The latest academic report on the school's education results reveal in broad terms that 85% of students routinely graduate within the 2 years of the legal education certificate program. 95% of students routinely graduate within 3 years, which means that 10% of students repeat one of the years in the program. Madam Speaker, it gives me great pleasure to also extend, albeit somewhat belatedly, heartiest congratulations to the Norman Manley Law School team, who now proudly holds the winning trophy for the Caribbean Court of Justice mooting competition in its 12th year after defeating the Hugh Wooding Law School at the first ever virtual meet. The Norman Manley Law School had previously won the competition in its inaugural year in 2009, and then in 2016, and again in 2018. As noted in the principal's report, mooting competitions are recognized as impressive vehicles for international and regional benchmarking of legal skills. As one judge of the court noted, in announcing the winner, there was a marked difference between students in the undergraduate program and those in the vocational program, thus underscoring the value added by the legal education program. Madam Speaker, it is noteworthy that altogether the 3 council schools have won the CCJ's competition in 11 of 12 years. The Norman Manley Law School also progressed to the advanced rounds of the Philip C. Jessup competition last month. This competition, the Philip C. Jessup Moot Court, is the most prestigious international law moot court in the world. Some here know it. On another occasion, I will address some issues that fall for consideration under this subject, including the challenges faced by graduates of the University of Technology and other non-UWI Bachelor of Laws degree holders, and the options to be considered to address these issues. I look forward to working with the Minister of Education to resolve the issues facing the students in the shortest possible time.
Absolutely.
Madam Speaker, I now turn to the office of the Parliamentary Counsel. I'm pleased to inform this Honourable House that over the reporting period, the OPC dispatched 179 complete drafts, with another 4 in progress on 73 bills. 16 of these bills were passed into law. I have set out in the written text those 16 bills passed into law. And I have also set out the details of the 73 bills by name and number of drafts per bill dispatched to the relevant portfolio ministries. And when the presentation is distributed, you will see how the work has been allocated among the various ministries, Madam Speaker. You know, contrary to the impression formed by some that the Office of the Parliamentary Counsel is primarily responsible for delays in the legislative process and claims that bills are usually stuck there, the Chief Parliamentary Counsel and her team do deliver in a timely manner when drafting instructions are clear and complete and policy issues are settled. At the same time, it is very true that the office is under-resourced for the size of our government and the robust legislative response that is required in so many areas to address so many issues in the society. I turn to the Law Revision Secretariat. The core objects of the Law Revision Secretariat, the LRS, is to increase access to the laws through the annual publication of the revised pages of the Laws of Jamaica volumes and the facilitation of the publication of laws online. The ongoing task of consolidating the laws of Jamaica is usually done on a year-to-year basis. That is to say, there is a revision year, and it involves reviewing all of the new legislation that are in force up to the cut-off date. And that cut-off date is December 31st of each year. And then they are to be included in all acts passed and operationalized, and all subsidiary legislation promulgated, both being duly gazetted, to determine what changes to the revised laws of Jamaica have been activated by the new legislation. Madam Speaker, I just say to my fellow parliamentarians that although it sounds technical, it is important that every member of Parliament understand what this means. It's not an area that is reserved only for the lawyers. We are the lawmakers, and we need to understand the context that we set for the nation. Madam Speaker, the Law Revision Act provides for the functions of law revision to be carried out by law commissioners. An assessment of how the Law Revision Secretariat has been functioning reveals that the current system may have to be reconceptualized, as the statute law commissioners are not now involved in the day-to-day task of law revision. Furthermore, the staff complement is not adequate to keep a pace with the volume and scope of work. The reclassification of posts to reflect the knowledge, competence level, and required skill sets to properly revise the law is still pending, even though a comprehensive strategic review was done. Madam Speaker, the entire system must be redesigned and appropriately resourced to make it fit for purpose.
Hear, hear.
To produce up-to-date and accurate legislative information online and elsewhere, yes, we must also reduce the lag time between the enactment and inclusion in the revised laws of Jamaica.
Yes.
Right now, Madam Speaker, I take no pleasure in saying ministries do not have a compilation of ministerial orders, and legal officers do not know where to find the gazettes with them. The goal is to have a dedicated website where the acts passed by Parliament and the subsidiary legislation can be published and circulated in a searchable database, which also includes sunset legislation and repealed acts of Jamaica, as well as gazettes containing legal notices and other relevant matters. You know, Madam Speaker, I recall my days as a judge of the parish court, how I lamented that our law was not available in a more user-friendly manner. I thought then how convenient it would be to see not only the primary legislation, the Acts of Parliament, but also the relevant regulations in one place, so that judges, lawyers, and others could easily access them. Later, as Attorney General, I decried the exclusion of the Memorandum of Objects and Reasons from prints after enactment, and I truly agonized when I had to look in so many different places to get a complete picture of the law, where regulations, including ministerial orders, were made under an act. Notwithstanding all of that, Madam Speaker, I'm pleased to report progress made on the work of law revision. Work commenced under the Ministry of Justice, and I assure everyone that the deficiencies identified will be addressed in due course. Madam Speaker, it gives me great pleasure to report that the Ministry of Legal and Constitutional Affairs has entered into a memorandum of understanding with the Jamaica Promotions Corporation, the JAMPRO, to introduce a comprehensive legal information portal. This project will be funded by the World Bank under Component 1 of the Foundations for Competitiveness and Growth projects. No longer will extensive time and effort be expended to identify gazette notices and laws. Once implemented, you will be able to get them right away. Madam Speaker, the Ministry intends to use the web portal to engage on law reform issues. This engagement will serve to inform both the public and the Ministry itself about the issues of concerns that are to be considered in the development of law reform proposals. The portal will also provide access to, among other things, the revised laws of Jamaica, and I'm talking about all editions from the 19th century to the present, the annual Acts of Jamaica from the 17th century to the present, the Jamaica Gazette publications, proclamations, rules and regulations, bills and acts, and the Gazette Extraordinary. I'm pleased to report that funding of the software and equipment, as well as technical expertise, have been secured from JAMPRO, and the project is expected to begin in 2023. At this time, material is being scanned and prepared for upload to the website when it is developed. The portal will include also the judgments of the court, what we call common law making. Madam Speaker, the creation of a Jamaica Legal Information Portal is also complementary to the broader efforts to modernize Jamaica justice sector institutions and processes. The broad programs of justice reform and the renewed focus on updating the laws of Jamaica, in particular, align and is grounded in the high priority accorded by the Andrew Holness administration to the resolution of issues affecting access to justice and the rule of law. More importantly, Madam Speaker, the program also supports the economic imperatives of the government in terms of improving Jamaica's business environment and competitiveness. Improvements in the availability of legal information should therefore be assessed as complementary to and part and parcel of the broader framework of Jamaica's economic growth agenda. Madam Speaker, the Ministry of Justice had commenced the process of operationalizing a new legislative production management system, the LPMS, a few years ago. This system is a comprehensive, modern, computerized tool capable of managing the life cycle of legislative documents, from drafting to publishing. Once introduced, it will connect all government entities involved in the drafting and publication of legislation. This will redound to a more efficient legislative review process and reduction in the time, in the amount of paper used. Implementation of the system has been affected by delays, as many things have been with the pandemic and other things. After conducting a gap assessment, my ministry has determined that an information technology consultant with experience in SharePoint implementation is needed to assist us in implementing the system. The consultant is projected to commence work by September of this year and complete the assignment over a 9-month period. This would see the rollout of the system by June 2023, all things being equal. Madam Speaker, the preparation of materials for upload to the Jamaica Law's online website is in progress. The Law Revision Secretariat has completed and delivered revised laws for 3 legislative years, 2016, 2017 and 2018, during the reporting period of fiscal year 21-22, and has also completed and finalized update for the 2019 statutes. The next steps are the completion of typesetting and proofreading for 2019 subsidiary legislation and for legislative years 2020 and 2021. Actual update of the website is underway with upload of 2016 revised laws. We're talking about the statutes and the subsidiary legislation, now 50% complete, as 70 pieces of new and amended legislation have been uploaded. Madam Speaker, the Acts of Parliament 2001 and 2005 to 2020 have been uploaded, and 80% upload of the Jamaica Gazette 2001 to 2021 has been achieved in the reporting period. A digitization project to convert the index copies of the Jamaica Gazette, proclamation rules and regulations, and extraordinary from the hard to soft copy for the purposes of preservation, maximization of storage space, as well as the creation of digital content that can be eventually organized and made available online to the public is ongoing. The targets and achievements of the Secretariat over the reporting period are set out in 2 tables in the printed presentation, and when it is circulated, you can see the detail of the work done, target set, and what has been achieved quarter by quarter, Madam Speaker. I now turn to the Law Reform Department. The primary function of the Law Reform Department is to constantly review the laws and then propose to the policymakers laws that are to be passed, reviewed, updated, or even repealed. The continued relevance of older laws is to be assessed and checks made whether they have been superseded by other laws. I'm advised by the Director of Legal Reform that all 19th century law on our books are now being reviewed. And in this regard, unlike in other matters, where the role of the Director of Legal Reform is a reactionary one, it is the Director who determines priority. Since priority is not determined in a vacuum, though, the criteria which guide the order of review must be carefully considered and even re-examined if need be, having regard to wider governance issues. Although there is currently no requirement for policy documents for law to be submitted to the LRD, but properly ought to be submitted, the LRD does review cabinet submissions and review draft bills. This allows for a determination of whether a proposal for new law is already covered by existing law, or if an existing law goes far enough, and also the role of other laws in achieving the desired goals. While it is the Attorney General that has ultimate responsibility for advising on the constitutionality of any proposal, the Law Reform Division also opines on the matter and attends to the Legislation Committee of the Cabinet where necessary, and provides technical support to the Joint Select Committee of the Parliament. Although, Madam Speaker, the LRD is challenged by paucity of resources, which impacts its response time, I'm confident that we will overcome when the wider public sector reforms that are now underway are implemented. especially the revised remuneration level, to enable experienced staff to be recruited and or retained. Notwithstanding all of the challenges, Madam Speaker, I'm pleased to say that the Law Reform Department is poised to play a more pivotal role in the conceptualization of legislative policy and the development of preliminary documents, including assisting with the drafting of cabinet submissions. I believe that a certain type of synergy is required among the different players who have a critical role in the lawmaking process if we are to achieve the reform goals timelessly. Consequently, I have shared with the Minister as he gives further consideration to the arrangement of his government for greater efficiency in the working relationships among ministries, departments, agencies, and in particular among this Ministry of Legal and Constitutional Affairs, the Ministry of Justice, and the Office of Attorney General, as well as the Parliament. In the meantime, I place before the Cabinet for its approval a proposal that will formalise arrangements across all of government on how to improve the flow of legislative work. I now turn to inter-ministry legislative collaboration. Madam Speaker, one of the strategic priorities of this ministry is to address the slow pace of legislative reform in the public sector by strengthening inter-ministry collaboration. The aim is to improve operational efficiency, speed, and the quality of legislation promulgated, because the legislative process has been affected by delays, culminating in critical pieces of legislation neither being amended, repealed, and replaced, nor developed and subsequently passed in a timely manner. The situation has been exacerbated by the lack of adequate human resources in some ministries, coupled with the crafting of ambitious legislative targets prior to the start of each financial year. Some targets, which are encompassed in strategic and operational plans, the annual legislation programme, and the throne speech, are not accorded priority and the concomitant dedication and focus by some entities. Madam Speaker, this Ministry of Legal and Constitutional Affairs cross-cuts all of government and, in fact, dips into other ministries with a supervisory role on legislative matters. To facilitate this work, I am pleased to inform the Honourable House that Cabinet has granted approval for the establishment of legislative teams in each ministry, to include the relevant policy officers, the relevant legal officers, and the relevant senior officers at the level of Chief Technical Director, Principal Director, or Senior Director. And they would be responsible, who would be responsible for working closely with the policy and legal officers to provide oversight for each ministry's legislative programme as part of my ministry's work to strengthen inter-ministry collaboration and advance the government's legislative programme. Therefore, we will be dealing with a focal point in each ministry, and internally they would have the responsibility of coordinating, regardless of the subject matter, regardless of the department, regardless of the entity, and then the Ministry of Legal Affairs interface there, provides guidance, technical assistance, etc. Mind you, Madam Speaker, this submission was debated and discussed in detail as ministers inquired exactly what is to be done. Since it's not the norm for another ministry to reach into other ministries and supervise aspects of the work, but it is part and parcel of what we're doing to rationalise government and to improve service to the people. Cabinet has also approved collaboration between the Ministry of Legal Affairs and the Office of the Cabinet in supporting and monitoring the legislative work programme and implementing strategies to close gaps identified using established and proven project management principles. Interestingly, also, Madam Speaker, is that there is going to be a public education program on the laws of Jamaica to augment awareness of, among other things, the legislative process, the role of all stakeholders in the process, the need for full compliance with the law, and in particular with the Charter of Fundamental Rights and Freedoms, and the administrative and public law requirements for the exercise of statutory functions. Madam Speaker, there will also be a projectized approach to law revision and law reform in principle, with the aim of establishing a law reform commission, similar to what exists in England. At a later stage, I will say more on that.
Madam Speaker, the member's time for speaking having expired, I beg to move that the time be extended to allow her to wrap up and conclude her presentation. May it please you, Madam Speaker.
The question before the House is that the member be given time to wrap up and complete her presentation. Those in favour? Those against? The ayes have it.
Thank you, Madam Speaker. So, going forward, all ministries will be required to work within settled time frames to produce the legislative outcomes. Madam Speaker, we are cognizant that there are capacity gaps within the ministries, and if these gaps are not closed, the desired objective will not be achieved. In this regard, my ministry will partner with a MIND, that's a Management Institute of National Development, to provide training in policy development and the preparation of cabinet submissions, which involves laws. The ministry will also collaborate with the Office of the Cabinet to conduct sensitization sessions to, among other things, improve the quality of cabinet submissions prepared by ministries in respect of law reform proposals. Madam Speaker, the ministry's portfolio responsibility for the subject of legal education will transcend the provision of monthly subvention to the Norman Manley Law School to further include implementation of a robust program to augment technocrats' knowledge and awareness of the law, which govern the operations of their entities, as I said before, the legislative review process and their role in the process. The ministry recognizes the need to improve knowledge and understanding of legislation in each ministry's portfolio. Enhanced knowledge and understanding will reduce, if not prevent, the government's exposure to court actions and ultimately liability. It will also help improve confidence and integrity in government. And I so look forward with much eagerness to implementing this public education program on the laws of Jamaica. The purpose of the program is to educate the technocrats. I say it and I say it again. I say it and I say it again because it is so important, Madam Speaker, so important. You know, the ministry has really hit the ground running. We are motivated and we are poised to achieve the results once we get the cooperation of the rest of government and the resources from the Ministry of Finance and the Public Service. Madam Speaker, before I turn to the final area of my presentation on constitutional reform, I should like to advise the Honourable House that a new bail act is coming. I wanted to table it today, but we are revising the wordings of some clauses. I will not say much more at this stage, Madam Speaker, except, and I want you to hear me well. I want you to hear me. I want everybody to hear me well. Madam Speaker, if you're on murder charge, you cannot be at large. If you're on gun charge, you cannot be at large. The bail will come shortly. Madam Speaker, I now turn to that subject matter of constitutional reform. Madam Speaker,
You're excited.
the continued symbolic presence of the British Crown in the constitutional makeup of our state and other Commonwealth Caribbean states has been repeatedly placed on reform agendas here and across the region, with Little England officially severing ties from Queen Elizabeth, Big England, and establishing the Republic of Barbados in 2021, and Prime Minister Holness's announcement of his government's intention to move on from a constitutional monarchy, eyes are now focused on the remaining Commonwealth Caribbean realms to see who will take the next step when. The mandate of this new Ministry of Legal and Constitutional Affairs includes spearheading the most meaningful and comprehensive post-independence constitutional reform work to be undertaken in our nation. The goal, Honourable Leader of Opposition, is to ultimately produce a new constitution enacted by the Parliament of Jamaica, establishing the Republic of Jamaica as a parliamentary republic, replacing the constitutional monarchy, and affirming our self-determination and cultural heritage. Madam Speaker, the work will be done in stages, but it has formally commenced. Just wait on. It has formally commenced. Before I get to timelines, I should assist in providing clarity on aspects of our constitutional history, because I hear so much being said about what we have, what we don't have, how we got it. I note misunderstanding in some quarters about how we got the Constitution and what may have been, what will be involved in changing it. Some believe that, like Barbados, it could have happened overnight and in a certain time frame. And some statements made in the media and on political platform about the conversations have not quite been accurate. Madam Speaker, for all practical purposes, the constitutional experts tell us that the history of the constitutional laws of Jamaica begins with the 1655 acquisition of the island by the British. The constitutional status of a British colony depended on whether it was classified as settled or conquered. But the peculiar circumstances surrounding the acquisition militated against the application of this dichotomy in Jamaica for more reasons than one. Madam Speaker, the island was formally ceded to Spain, by Spain to England in the 1670 Treaty of Madrid between England and Spain. And it ended the war which began in 1654 in the Caribbean, in which England conquered Jamaica. The title of the Spanish crown had itself been the subject of legal dispute, and it is doubtful whether on restoration the king could adopt and ratify an act of illegal warfare. Furthermore, the Spanish administrators had negotiated an agreement with the English invaders by which the Spanish were permitted to withdraw freely from the island, leaving no settlement or administrative structure. Ever wonder why we don't have any institutions from the Spanish period? From the beginning, therefore, Jamaica came to be treated as a settled colony, but the peculiar circumstances, they say, sowed seeds of legal problems of far-reaching constitutional importance. Early on, Madam Speaker, Jamaica suffered a military government administered by the commanders of the invading British forces. Edward Doyle was an officer of the original 1655 expedition. He survived his superiors. He continued to administer the affairs of the island under military jurisdiction, assisted by Executive Council of officers because of the political uncertainties in England, until he was formally confirmed in the position of governor in 1661. As the first governor, he did very little to develop the civil institutions. And I'm citing this for a reason. When Lord Windsor replaced Doyle and became the second governor in 1662, the Royal Commission and instructions to him empowered him to govern in accordance with all such laws, customs, and institutions as are exercised and settled in the other colonies and plantations, or such others as shall, upon mature advice and consideration, be necessary and proper for the good government and security of our said island of Jamaica, the said island adjacent, provided that they were not repugnant to the laws of England, but agreeing thereto as near as conditions of affairs will permit. Governor Windsor was also empowered to call assemblies together and to make eminently necessary laws for 2 years, unless they were conferred by the Crown, to levy monies, provided that they were not repugnant to the law of England. Listen to this. The Assembly, which met in 1664, immediately gave notice of the constitutional doctrine to which it would subscribe. One of its first enactment was a law declaring that the laws of England were in force in Jamaica. An early report of a reply from Governor Modiford had this to say: right reason, which in the common law of England is esteemed and of force amongst us, together with Magna Carta and the ancient statutes of England, so far as practicable. Madam Speaker, that is a very short and abridged story of how the laws of England became the laws of Jamaica. The early constitutional history is to a large extent concerned with the struggle of the inhabitants under an early form of representative government to assert claims to the privileges and rights of the English settlers. That, Madam Speaker, is why the records show us aspiring for certain things. Let me now turn specifically to the making of the Constitution. Critics say, though independence was supposed to mark a definite break from the colonial past, paradoxically, it seemed obvious to the Constitution makers that the Constitution ought to be, as far as possible, continuous with the past. They also say that the People's National Party nationalism more or less surrendered to Anglophilism of the class from which it came, and more generally the society it hoped to reform, because at no time did they seek to assess critically the applicability of British institutions to the Jamaican context. On the contrary, the colonial connection should go in order that the party might lead the way to bringing British political culture to Jamaica. In the defining years, it is said that the People's National, in the defining years, are coming to tell you, that's not the end of the story. Let's not quarrel. In the defining years, it is said that the People's National Party, I don't understand, just the mention of parties wake up everybody. Interesting. Madam Speaker, it is said that in the defining years, the People's National Party allowed more importance to the fact that all our ideas about politics come from Britain. All the institutions to which we are accustomed are British. And this is actually found in the PNP pamphlet of Join the Party around 1939. That's not the end of the story. I'm setting it out for a reason. Don't get impatient. Don't get impatient. To that extent, the advocacy was for the type of self-government which was democratic and fundamentally British. Ladies and gentlemen, this is what the records reveal. I'm not making it up, and you can check it. But I know not everybody will dig into the record. Absolutely. Wait for the rest of the story. So hear this, Member Jackson, through you, Madam Speaker. Norman Manley, described as the father of Jamaican nationalism, said he made no apology for the fact that he did not attempt to embark on any original or any novel exercise for constitution making, but deliberately opted for what they were familiar with. The system of parliamentary government, which over the years, listen man, chairman, the system of parliamentary government which over the centuries had been evolved by the British people, who display the most unique genius of any people in history for devising a form of government acceptable to the people. It was a system they understood, said he, and which we had been operating for many years with sense. He felt it was a system which was consistent with the sort of ideals we had in this country, and so it was not difficult to decide to follow that familiar system with those modifications they thought the circumstances of independence deserved. And I invite you to look at the Jamaica Hansard, 1961 to 62, at page 719. It doesn't stop there. The report, Madam Speaker. You know, I hear so many things about how we got what we got. I thought it very important to just check the records, dig through the files, and just help to inform this Honourable House and those listening. The report of the Joint Committee records at page 18 that a considerable body of opinion which appeared before the committee favoured a non-monarchical head of state. Most of the submissions in this regard were based on the assumption that independence had to involve some identifiable break with the past for it to become an extraordinary national experience. Yes. The proposal for a constitution whereby Jamaica would become a republic within the Commonwealth with a ceremonial president as head of state, with the importance of the symbolic difference that the head of state should derive the powers under the Constitution as the representative of the Queen, was rejected without the Joint Committee ever given a full explanation. The report, which was unanimously adopted by the legislature, merely stated that the Constitution provided for Jamaica's becoming a constitutional monarchy, while acknowledging that there were many proposals that Jamaica should become a republic, with some favouring a republic within the Commonwealth of Nations and a small number favouring a republic outside of the Commonwealth. The committee took the view that, in substance, there did not appear to be any fundamental difference between its preferred form, constitutional monarchy, and the proposal for a ceremonial presidency. So, Madam Speaker, at the court at Buckingham Palace on the 23rd day of July, 1962, the Queen Most Excellent Majesty in Council, Her Majesty, by virtue and in exercise of the powers in that behalf by subsection 1 of Section 5 of the West Indies Act, was pleased, with and by the advice of Her Majesty's Council, to order and thereby promulgated an order cited as the Jamaica Constitution Order in Council 1962. It was reportedly signed by one W.G. Agnew. The Jamaica Constitution Order in Council 1962 provided that the orders in Council specified in the first schedule, that is, the Jamaica Constitution Order in Council 1959, the Jamaica Constitution Amendment Order in Council 1959, the Constitutional Amendment Order in Council 1961, referred to as the existing orders, were revoked. Notwithstanding the revocation, the Public Service Regulation 1961, we still have it. The Judicial Service Regulations 1961, we still have it. The Police Service Regulations 1961, we still have it. The Jamaica Constitution Retirement of Entitled Officers Regulations 1961, some amendments have been made, we still have it, which were made under them, and all amendments thereto were to continue in force, subject to such adaptations and modifications made. All laws which were in force in Jamaica immediately before the appointed date were to also continue in force. Madam Speaker, the Constitution of Jamaica was set out in the second schedule of this Jamaica Constitution Order in Council 1962, with the appointed date of the 6th day of August 1962. You know, Madam Speaker, we may continue to engage in spirited debate on why we got what we got, but I think it's important to say that it's been a long time coming, but the change is going to come. Okay. It's going to come. So before I turn, I can't sing. If I could, I would mellow the tune. Before turning to the why, the what, and the when of the constitutional work, permit me to just provide some further information on how we got the Independence Constitution. It is important for the work to come. Yeah. On the 19th of July, 1962, an act to make provision for and in connection with the attainment by Jamaica of fully responsible status within the Commonwealth was passed by the English Parliament. Simultaneously, on the said 19th July 1962, the legislature of Jamaica passed the Jamaica Independence Act as an act to make provision for and in connection with the attainment of fully responsible status within the Commonwealth. These are 10 and 11 Elizabeth II at Chapter 40. Madam Speaker, no, you know, it's really good to do research from time to time. Yes. And when I said earlier that the work that I have to deal with on a daily basis really deepen my knowledge on so many areas. So this act, the Jamaica Independence Act, It provided that as from the 6th day of August, 1962, we all know what that day is, but in that act it's referred to as the appointed day. Her Majesty's government in the United Kingdom shall have no responsibility for the government of Jamaica, and no act of Parliament of the United Kingdom passed on or after the appointed date shall extend or be deemed to extend to Jamaica as part of the law thereof. And from that day, the provisions of the first schedule to the Act shall have effect with respect to the legislative powers of Jamaica. And those powers still remain. The Jamaica Independence Act is deeply entrenched in our Constitution. But hear this, Madam Speaker. Among other things, the first schedule provides that the colonial laws, the Validity Act of 1865, shall not apply to any law made on or after August 6, 1962 by the legislature of Jamaica. No law and no provision of any law made on or after August 6 by the legislature of Jamaica shall be void or inoperative on the ground that it is repugnant to the law of England or to the provisions of any act of the Parliament of the United Kingdom, including the same Jamaica Independence Act which was promulgated by the United Kingdom, and to any order, rule, or regulation. But you know, there is another power that has been hiding in this act.
Oh, yeah?
Deputy Prime Minister, I think you may be interested in this one. The Jamaica Independence Act provides that the legislature of Jamaica shall have full powers to make laws having extraterritorial operation.
What? Tell us what it means.
Believe it or not.
Tell us what it means.
This is in our Constitution. Extraterritorial operation. Because of I'm a little surprised. Not that I didn't know it, I knew it. My expression of surprise is based on so many things I've heard about what we can and cannot do as a parliament, particularly in addressing organized crime, particularly in addressing, money laundering, countering financing of terrorism. And who says what is even more surprising. And that is why I say perhaps they are unaware that this Parliament's legislative power extends extraterritorially. And we can't change this without a referendum. And I don't think we would ever want to change this because it's the Independence Act. So, nothing in the Act shall confer on the legislature of Jamaica any power to repeal, amend, or modify the constitutional provisions otherwise than in such manner as may be provided for in those provisions. Constitutional amendment provisions. And when the law speaks of the constitutional amendment provisions, it means the Independence Act, any order in council made before August 6, 1962, any law or instrument made under a law of the legislature of Jamaica made on or after August 6, 1962, which modifies, amends, or enacts, reenacts, with or without amendment or modification, or makes different provision of any such law or order in council or any such law or instrument previously made. And by the way, what is set out here is the same definition of amend in the Constitution, which we will have to contend with, even if you're tidying up. The audience is not just those who are present in Parliament. We could have done much better, many argue, with the powers that were given to us on independence. In fact, like I say, some people express surprise when they are reminded or told for the first time that the Parliament of Jamaica can pass laws having extraterritorial operation. Be that as it may, I think that there are many lessons to learn at the juncture at which we are. So, Madam Speaker, this now leads me to the crux of the matter. Our Constitution has three types of provisions. We've said it before: ordinary provisions, ordinarily entrenched provisions, and deeply entrenched provisions. And the procedure for amendment is set out in the Constitution. For the ordinary provisions, a majority of all members of both houses is required, not just the majority of those present and voting, as is required for ordinary laws. The deeply entrenched provisions, for the vote, we require 2/3 in both houses, and we know that it is not possible to secure 2/3 vote in the Senate without cooperation across the aisles. And then any bill which is amending a provision which requires this vote has a delay period that is built in. 3 months at the start, 3 months at the end. So alone you have 6 months of dead time. The law also provides that for those provisions which require the 2/3 vote but do not require a referendum, if the cooperation of the Senate is not received, it can go to the people, and a 3/5 vote would suffice to approve. And then we have the deeply entrenched provisions, which we will be dealing with. In fact, we'll be dealing with everything. And these provisions, which include the provisions relating to our Parliament and the Queen as our head of state, these provisions are deeply entrenched, and we need the vote of the people. After the bill has gone through the House with the delay time, and the time supposedly is to be used for proper consideration, to inform the people, get them on board, explain in details to them what it is that they will be required to do, to have parliamentarians think long and hard about the next steps. We will have to go to the people. Madam Speaker, I've been looking at Jamaica's attitude to referendum, because we will have to go there. We are going there, and we're going there hopefully by the time the next election comes around, unless more pressing matters or something else overtake. But that is the aim. Madam Speaker, we have quite a bit of work ahead of us to do. Based on the amendment provisions of the Constitution, the reform work to be done in order to achieve the goals of producing a new constitution passed by the Parliament of Jamaica will therefore require cooperation between the government and the parliamentary opposition, as well as the seal of the people. As I say, it is a sine qua non. The process, therefore, must be inclusive and reflective of representativeness and broad-based performance. Madam Speaker, there are important substantive and procedural issues to be resolved to ensure a smooth transition to a republic. I've looked at the recommendations that have been made, and each recommendation that I have looked at will require careful thought as well as substantial resources to implement them successfully. To further the process of moving from recommendations to action, I propose to appoint a constitutional reform committee to include representatives from the government, parliamentary opposition, relevant experts, and the wider society. Madam Speaker, time did not allow me to have a follow-up conversation, exchange, outside of this medium with the Leader of the Opposition. And I say it is not my intention to have the discussion that should be had based on our exchanges in this forum, but I do believe that some of what I will say will allay the concerns that you have expressed. So I have written to the Leader of the Opposition with a request for him to name 2 members of the Parliamentary Opposition to this committee, which is now being constituted. I have set out the work to be done by the committee in very broad terms, specifying, among other things, that it will involve at this stage the conduct of a thorough and comprehensive review of the 1962 Constitution, including the 2011 Charter of Fundamental Rights and Freedoms, as well as recommendations for reform made through the various constitutional reform commissions and committees in the past. Ultimately, to implement an ambitious reform agenda settled by consensus. And I've said that the ultimate goal is a constitution enacted by the Parliament of Jamaica. It's not just amending what is contained at the 2nd schedule of the Order in Council. No. Madam Speaker, the Leader responded with expressions of concerns, and it is obvious to me that he thinks that the approach is meant to delay the matter. Yes, that is what I sensed from your response. I sense that you are of the view, Leader of Opposition, that the relevant parameters, in fact you have said so, for Jamaica to become a republic have already been agreed by the 2 major political parties, arising from the extensive constitutional reform consultative processes over the past 25 years. And you've also said that the required legislative research has already been done. I take no issue with you, because it is true that much work has been done. But it is also true that important substantive issues are yet to be settled. And these are the more difficult issues, because not only government and parliamentary opposition must be on the same page, but the people. I think collectively as a nation, we need consensus on the direction we want to go in. It doesn't now exist. For example, the requirement for referendum and our own experience and the outlook on referendum makes the society gun shy. Going forward, is this a process that we need? And if yes, exactly for what? To amend the procedure, a referendum is required itself. Exactly. This issue has not been settled. The reform work will involve a thorough and comprehensive review of the Constitution, as we have to determine the extent to which the existing structure of government ought to be modified or preserved. In the same way that for very practical purposes, all that existed prior to independence could not be got rid of. And I'm not saying that people are saying we must get rid of it. We cannot now get rid of all we have. The same dilemma that we faced between the desire for change and the necessity for continuity is being faced now. We must not lose sight of the fact that Jamaica boasts a high degree of stability in its democracy, which should never, ever be taken for granted. At the same time, while it is not necessary to reconstruct our whole system of government. One problem with the Westminster system is that many of its rules and practices, the rules and practices under which it operates, do not have the force of law. Without knowledge of these rules and practices, knowledge of the legal rules alone is incomplete and sometimes misleading. These rules, principles, and practices are essential to an understanding of the relationship between what may be called the political constitution and the legal constitution, and give constitutional meaning to apparently disparate events. The pragmatic approach that predominated at independence avoided the difficult task of stating the shared political beliefs and assumptions on which the system of government depended. Many informal practices and understandings are observed between the main parties in the House. In this House we have two. And between the front bench and the back benches. Such practices are not contained in the House's standing orders, but they directly impact parliamentary business. While it may be unnecessary to reduce all of them into writing, the fact is we do have a written constitution, unlike Whitehall, and some things are not adequately provided for. The simple truth is that we must radically alter the way Parliament works, and must therefore determine what new pace will be set by the Constitution itself. Laws are to be passed for peace, order, and good government. We in Jamaica have been generally reactionary in our approach. Most of our laws are passed in response to some bi- or multilateral conditionality, as a condition precedent to getting funding or to avoid sanctions. Where laws require state agencies to report or be accountable to the Parliament, their reports must be read and interrogated by the Parliament. No, it is primarily when the news reports on something that there is a scramble to respond. In the past, agencies of government go for many years without submitting any annual report, and there is no evaluation of the effectiveness of those agencies, and the people suffer as a result. And in fact, MPs are required to take on functions that are properly and legally vested in other agents of the state. I am not saying that a constitutional solution is required to address these problems, but one may be required. For example, in how we provide for accountability in the political directorate as well as in the civil and public services. After all, we subscribe to the principle of constitutional supremacy, not parliamentary supremacy. So we must therefore reassess the constitutional parameters. In signalling an answer, Leader of the Opposition, to why we must look back at the Charter, I pray in aid the very wise words of the Right Honourable Norman Manley, when he called for careful re-examination of the rights clauses of the initial Bill of Rights at Chapter 3. This is what he said: "If you are not careful, you may write yourself out of the right to do many things which are useful and good for the community." Look at the proceedings of the House of Representatives on Tuesday, January 23, 1962, at page 722. Madam Speaker, I maintain that responsibility guarantees rights to deal with the criminal terrorists that are sucking the life out of our society. And who know their rights better than their wrongs. Lord knows we need to be wiser than Solomon, stronger than Samson, and more patient than Job to deal with them. Madam Speaker, I'm about to close. Until we achieve this important constitutional reform goal, the executive authority of Jamaica remains vested in Her Majesty and is exercised on her behalf by the Governor-General. As such, I should also like to use the opportunity to add our congratulations to Her Majesty Queen Elizabeth II, our Sovereign for the time being, on the occasion of her Diamond Jubilee, marking her 70 years of reign. Having said that, I must also say to anyone who is in doubt, we are making the change. We are making the change. Although we can agree that Queen Elizabeth II has always comported herself with the dignity befitting her office and status, thereby endearing herself to many the world over, we can also agree that the legacy of colonialism and slavery bequeathed to us by the British monarchy still impacts us. The persistence of both overt and subtle discrimination against people on the basis of class and colour continues to influence our society and the world over, in the forms of disparity in education, in health, wealth, income, social mobility, and almost any other metric we might use to measure equality. Madam Speaker, in the 6 decades of independence, Jamaica has made much progress, but we have much work still to do. Our recent progress must not obscure the reality of our past or the continuing effects of the past on the present. Therefore, in this year of Jamaica's Diamond Jubilee and that of our Sovereign Lady the Queen's Platinum Jubilee, we say with due respect, but without apology, borrowing the words of our own renowned constitutional law expert, Dr. the Honourable Lloyd Barnett, the historical essence of a monarchy as a form of government is rule by one person. An important characteristic of monarchism is the obeisance and adulation and submission that it demands of its subject. This relationship is enhanced by the dynastic nature of the monarchy, by which there is succession of rulers of the same line or family. The sovereign being selected on a hereditary basis and not by virtue of his or her qualities, had to claim some dynamical powers exclusively and divinely bestowed. In return for the allegiance of their subjects, the monarch had the responsibility of defending the people against external enemies and criminal violence. The monarch thus came to be the embodiment of the national spirit and the symbol of patriotic pride. The majority of colonial people and the inhabitants of Jamaica were not subjects of this imperialism, but through the slave trade and slavery were its oppressed objects. Whereas, therefore, the monarchy can truly be representative of the Englishman's pride in history of his country and may symbolize British national aspirations, unity and continuity, it cannot have the same significance for the majority of Jamaicans. In the event of death or abdication of the present Queen, Charles, or anyone who, according to the hereditary principles of English law, succeeds her, immediately becomes our King or Queen and head of state, without Jamaica having any say in the matter. This is highly undesirable and inappropriate. There are many steps to be taken between now and the tabling of a new constitution. I will advise when the committee is fully constituted. I will have discussions with the leader of the opposition, and I will keep everyone up to date on all progress made. It is my intention, in leading the process, to work assiduously to place something before the Parliament, unless, of course, something more pressing happens to overtake for the start of the next session. And session is defined in the Constitution to mean, in relation to a house, the sitting of that house when it first meets after the prorogation of Parliament. Madam Speaker, so there it is. The work is to get it in time for the next session so that the steps can be taken in time for the next general election. We can get to there. So I will, yes, the work between now, the next session would start at the start of the year. It's when the Parliament opens. Yes, yes. So it's the start of the legislative year, right? Because there are certain rules around what is done within the session of Parliament and what goes between sessions. And there is much to be done and how we will do it. But those will not be set out here in this presentation. So, Madam, in closing, I want to thank God for His grace and His mercies. Madam Speaker, I want to thank God. And I am confident that He who began this work in me is faithful to bring it to completion. May our Eternal Father continue to bless our land and guard us with His mighty hand. And Member Jackson, through you, Madam Speaker, it's metaphorically speaking, I know my limitations, but you know they also say, metaphorically speaking, of course. Madam Speaker, I thank you.
Madam Speaker, we really want to thank the newly minted Minister of Legal and Constitutional Affairs for what is really a marathon presentation. And I think that she really gave us, in fact, she invited us to her lecture on the origins of the Constitution of Jamaica. And Madam Speaker, it was very instructive, because I think it brought to recollection some uncomfortable truths that no doubt we will have to deal with down the road. Madam Speaker, on the basis that we are at public business, I would ask that you invite the Minister of...
Maybe we should suspend the sectoral debate and then...
we do that. We'll do
yes.
that. I just,
and then go ahead.
Because we're... Yes. Definitely, Madam Speaker, it's just the sequence. And I just to indicate to you my intention in that regard. So that is the intention for us to do in this phase of public business. The withdrawal of the bill, and the Transport and Mining Minister so to do with regards to Traffic Regulations 2020-22. Madam Speaker, the sectoral debate will continue tomorrow, when the Speaker at that time will be the Minister of Gender, Culture, Sports, Entertainment, and so many other things. the Honorable Olivia Babsey-Grange. So until then, I invite you to suspend the debate for today to be resumed tomorrow at 2 p.m. May it please you, Madam Speaker.
The question before the House is that the sectoral debate be suspended until tomorrow, when the Minister of the Honourable Olivia Babsey-Grange will present in our sectoral debate. Those in favour? Those against? The ayes have it. Debate is suspended. And we move now to, we're still on the continuation of public business, so we will move now, House Leaders, to the withdrawal of the bill.
Which the member from Manchester North East and Minister of Mining and Transport will do, Madam Speaker.
Minister.
Thank you very much, Madam Speaker. Madam Speaker, I now seek the leave of the House to withdraw the item listed at number 1 under government business, on the order of business, the Road Traffic Regulations 2022. And, Madam Speaker, this is on the basis that we have made some further amendments, and the replacement will be tabled as well today.
Members, is it the wish of the House that the item listed number 1 under the heading Government Business on the order of business, the Road Traffic Regulations 2022, be withdrawn? Those in favour? Those against? The ayes have it.
Madam Speaker.
No, sorry. When we go to motions to be done,
I now ask for the recommittal of the items. Announcements and notices of motions given orally to enable me to table a new road traffic regulations.
The member will no doubt at the recommittal of motions given orally will make the appropriate request of the Honourable House. So in the interim, Madam Speaker, I would move that the standing order be suspended to allow for a reversion of the order as we had at the point in which...
Members, the question before the House is that the standing orders be suspended to allow us to revert to the items on today's agenda, starting with statements by ministers.
So, Madam Speaker, the House no doubt will approve. So please put the question.
Those against? The ayes have it. Thank you. Statements by ministers.
Yeah, Madam Speaker, the Minister of Finance, yes, and the Public Service will make a statement.
No, sorry. I'm just going to beg the indulgence of the House. The only avenue on which I could just say a few words on what was tabled, just explanatory notes, that's all. The intent is not to make any policy statement. It's just that Section 114 of the Constitution gives authority for the establishment of the Consolidated Fund, into which shall be paid all revenues of Jamaica. And Section 15, subsection 2 of the Financial Administration and Audit Act indicates that the Accountant General shall be the custodian of the Consolidated Fund, with Section 15, subsection 4 of the Act mandating that the Accountant General shall submit to the Minister such statements of account on the financial position of the Consolidated Fund at such times and in such a form as the Minister may require. The statements contained in this document are prescribed in Section 24G of the FAA Act, and they relate to the Consolidated Fund for the year ended March 31st, 2022, and have been prepared by the Accountant General and submitted for tabling. And the reason for just making the editorial comments, just to make sure that there's the word estimates refers to the revenue estimates for the financial year 21-22, and these are the original estimates tabled in Parliament. The column receipts are the actual receipts of the Consolidated Fund. Now, actual receipts can differ from the central government operations table, and none of this is new, but just so that when we have conversations about this, we can speak, with accuracy. Actual receipts differ from the central government tables due to timing differences between amounts collected versus amounts transferred to the Consolidated Fund. Once revenues hit the government of Jamaica, they are recorded in the central government tables as revenue. This is an accounting of the Consolidated Fund, and some revenues in the Consolidated Fund when it hits the Consol Fund, and there can be timing differences, as you can no doubt imagine. And just explanatory notes on statement 7. The bauxite levy is not transferred to the consol fund, but is managed separately by the Development Bank of Jamaica. That's a long-standing provision, and the financial statements consist of a number of statements 1 to 9, as well as notes. I just wanted to provide those editorial comments to make sure they're properly understood. Thank you, Madam Speaker.
Announcements.
Tell them to table the regulations. Laid on the table of the House today are the following: Government of Jamaica financial statements of the Consolidated Fund for the year ended March 31, 2022. Annual report on audited financial statements of the Airport Authority of Jamaica for the financial years 2017 to 2018, 2018 to 2019, and 2019 to 2020. And the Road Traffic Regulations 2022 and its resolution from the Ministry of Transport and Mining.
Bills brought from the Senate.
The following is a message from the President of the Senate. To the Honorable House of Representatives, I have the honor to advise the Honorable House of Representatives that on the 3rd day of June 2022, a bill entitled An Act to Amend the Bank of Jamaica Act was passed in the Senate without amendment. Signed, Thomas Tavares Finson, OJ, CD, QC, JP, President of the Senate.
Petitions, papers, reports from committees, notices of motions given orally. Minister Shaw. Can I, members, members on both sides of the aisle, please. I know you're speaking clarity, but there's another speaker on his feet.
Thank you, Madam Speaker. Madam Speaker, I beg to give notice that at the next meeting of the House, I'll move. Whereas Section 110 of the Road Traffic Act, hereinafter referred to as the Act, provides that the Minister may make regulations generally for giving effect to the Act. And whereas subsections 3 and 4 of Section 110 of the Act respectively provides that regulations made in relation to tests to be taken for driver's licenses or certain specified alternatives to such tests, and regulations which provide for a custodial sentence shall be subject to affirmative resolution. And whereas the Minister responsible for transport on the 7th day of June 2022 made the Road Traffic Regulations 2022, and whereas it is desirable that the Road Traffic Regulations 2022 be affirmed, now therefore be it resolved by this Honourable House as follows. This resolution may be cited as the Road Traffic Regulations 2022 resolution. The Road Traffic Regulations 2022, which were laid on the table of the House on the 7th day of June 2022, are hereby affirmed. And Madam Speaker, I also beg to give notice that at the next meeting of the House I will move to introduce and have read a first time a bill shortly entitled the Transport Authority Amendment Act 2022.
Who is that?
Questions and answers to questions.
Madam Speaker, I understand the Minister will answer the questions tabled in my name.
Madam Speaker, I rise to answer the questions posed by member from South East, St. Andrew. Would the Minister confirm if the government has sourced the $25 million US equity contribution for the Harmony Cove project? Response. The shareholders of Harmonization Limited, which are the Development Bank of Jamaica, can you help me? It's just one page. It's one page each. You can give it on this side as well. The shareholders of Harmonization Limited, which are the Development Bank of Jamaica and the National Housing Trust, intend to provide an aggregate amount of up to $25 million US to Harmonization Limited to meet the proposed equity injection by that company in the Harmony Cove Limited development project. The investment by these agencies will be made in tranches in line with an agreed and documented program that will be matched with private investment in the Harmony Cove project of a comparable amount. The investment of each tranche will be linked to the fulfillment of practical and reasonable milestones that ultimately lead to third-party financing commitments being in place for the development of the project. Question 2. If yes, please indicate what the monies have been used for. Response. Not applicable, as the funds have not yet been disbursed. When the funds are released, they are to be used for the final pre-development detailed design work in line with an agreed schedule of deliverables and governance plan that is consistent with projects of this nature and scale. Question 3. If the answer to part 1 is no, please indicate the reasons it has not been done. Response. The investment is awaiting the final details of the governance plan and milestone that are to be agreed by all parties. The parties have indicated that this is actively being negotiated and finalized. 4. Would the Minister provide an update on the status of the project and specifically state whether the joint venture partner, Tavistock, has fulfilled its obligations under the agreement? Response. The parties to the existing agreements in respect of Harmony Cove have a contractual duty to support the development of the project with capital contributions to fund the designs, to secure permits and incentives that would ultimately allow the project to raise financing and be developed. Specific aspects of the plans will, of necessity, be adjusted over time to reflect evolving market requirements for resort tourism, changing legal and regulatory requirements, and changing conditions in financing markets. The parties have affirmatively expressed a continued commitment to develop the project in line with their existing framework agreements and, where appropriate, to negotiate in good faith to mutually agree adjustments to the agreements to reflect current market conditions. Neither party to the joint venture has made a claim or demand or otherwise expressed that the other party has not fulfilled its obligations under the applicable joint venture agreements. Harmonization Limited is operating on this basis with respect to Tavistock Group and the joint venture. Part B, whether there are any other obligations on the part of the government that are outstanding. Harmonization Limited has a specific obligation to use best efforts to facilitate the procurement of government approvals and incentives to develop the resort. Both joint venture partners to Harmony Cove Limited, Tavistock Inc. and Harmonization Limited, are actively engaged in pursuing these approvals and incentives. The government will, of necessity, grant incentives, permits and approvals to this and any other development project in line with applicable laws and regulations in place. Accordingly, the government stands ready to give effect to an integrated resort order for the project that is consistent with the current legal framework and to approve a tax incentive package under the General Legislative Review of the Income Tax Relief Large-Scale Projects and Pioneer Industry Act of 2013 and any other applicable incentive framework in place. Is that it? Let me know. Yeah, and Importantly, Harmonization Limited is committed to supporting Harmony Cove Limited in securing the required approvals and incentives, and is well-resourced to support Harmony Cove Limited in making the necessary applications, and has the assurance that they will be handled expeditiously.
Minister, I table these questions because I think, as the House would know, this project has been in gestation for a very, very long time. There is a sense that we're really not moving at the pace in moving it from gestation to reality. And my understanding, while the 25 million commitment was made, there's a significant smaller sum that the company is willing to match to begin to make some progress on the plans to implement this development. My follow-up question one is the company awaiting a disbursement of somewhere in the region of about $4 million US, which they would match to begin to move the process forward? And is the government, given the long gestation and the delays, is there any contemplation that the government has in terms of terminating the arrangement with Tavistock and seeking another joint venture partner?
So thank you for the follow-up questions. This project has indeed taken a very, very long time, and the truth is the way this project was conceived is inconsistent with Jamaica's, the direction that Jamaica is in. Right? If this came up today, it would be undertaken and designed and conceptualized in a completely different manner. And the contradiction, inherent contradiction, is a part of the challenges. I.e., this is a project that should be entirely in the private sector, and not one that the government should be caught up in to the tune of 50% equity shareholding. Be that as it may, the historical antecedents are what they are. The government is committed to seeing this project through. Before the government, the equity commitment that has been made, before it can be drawn, there are certain governance arrangements that are currently being negotiated between the parties to ensure that the project, as best as possible, achieves its objectives in a manner that preserves the interest of Jamaica. Once those arrangements are completed, the government shareholder and the government shareholders have the capacity to make the required equity contribution. So to the second part of the question, given the progress that has been made and the underlying commitment to the project, at this time there's no need for the government to be seeking alternative ways for the development of that land. The conversations are happening, and progress is being made, albeit slowly. Once the large-scale Pioneer and Industries Act is tabled, and I expect that to be tabled within this fiscal year, it will provide us with the avenue in a transparent way. And hopefully we'll have your support when we do that, which I know, no doubt that we will, and a transparent way to concretize, or to crystallize rather, the incentives that the project the incentives that are a part of the framework, the incentives, to crystallize incentives for the project as agreed.
So it's fair to say we are not at a stalemate in terms of the negotiations with the joint venture partner. That progress is being made on that. And secondly, what is the cost to the shareholders to maintain the Harmonization Limited on an annual basis?
A very good question, sir. We are not at a stalemate. No. We're not at a stalemate. Progress is being made. With respect to the cost, I don't have the numbers in front of me, but Harmonization Limited, which is our shareholder, the government's shareholder, owns the harmonization lands, and also owns some other lands in that area that adjoining. And the revenues earned are sometimes, in some years, not sufficient to cover all of the expenses. So there is an amount of a drag, so to speak, in the order of magnitude is that I can recall. I don't want you to hold me to it, but it's in, it's not more than. No, let me not say if I don't have the number in front of me. But it's not. It's so yes, there are annual losses that Harmonization Limited makes from the expenses that it has. Because it doesn't have sufficient revenue at the moment to cover those expenses. However, this investment project is of a particular nature that, or let me, even before we go to that, the Harmonization Limited has substantial assets. The asset base is tremendous. And provided that this project is successful, that asset base will only increase and increase dramatically based on the success of this project.
So the two government entities who would be the main shareholders are DBJ and NHT. You didn't want to commit to a figure, but my understanding is on an annual basis, it may be somewhere in the region of 200 million being both to support Harmonization Limited. And really raises the question, particularly for NHT. And I know this predated you, but whether the NHT funds should really be used continuously, as it has been from the inception, to support harmonization in this way, given all the other challenges that the NHT has. So, my question is, how quickly do you think we can get to a situation based on the negotiations where that burden which the taxpayers ultimately are bearing will be removed and those funds can be directed in a different way?
I was just trying to see if I could pick up very quickly what the financial statements for Harmonization Limited. But the last time I saw statements, remember, the annual losses, if you will agree not to, I'm not going to hold you to that number, you don't hold me. The annual losses were less than 20 million a year, the last time I saw it. So it's a big amount, but it's not to the order of magnitude that you're concerned.
The figure, I'm not talking about losses, I'm talking about the drawdown to support the operations of harmonization, not the losses.
Yeah, but remember that it's the losses that need to be financed. So it's the losses that determine the amount of the drawdown. Right? So the losses represent the amount by which expenses exceed revenue. So that is what the shareholders, being NHT and DBJ, would be responsible for. And I get the exact figure for you, but my recollection the last time I saw it, it was in the region of $20 million a year or less. Now, it is precisely because NHT is the shareholder, and we all acknowledge that predates me, right? It's precisely because NHT is the shareholder why we want to be very careful that all the I's are dotted and the T's are crossed before that equity contribution is made. The last thing, when that equity contribution is made, it's important. And there's always a risk. There's always a risk. But we want to minimize the risk that the project stalls thereafter. Once that equity contribution is made, we want to have as much assurance as is humanly possible that the project will move all the way to completion. Yeah.
Just for clarification, Minister. So you're making a distinction between the capital that is being paid in on an annual basis to finance losses and the equity injection that you're talking about here that you're saying has not yet commenced? And why? So what are you treating the money that has been expended by the two shareholders on the operation, the losses of the operation so far? You're saying that the entity has been incurring losses, you're saying around up to 20 million a year is your recollection. So we mustn't hold you to that number. But you're saying that the 25 million equity injection to the shareholders has not yet happened. So what are you treating those resources that they're using to fund the losses thus far? And why are you treating that as separate from the equity? Yeah.
Okay, the money is going to two different destinations. The money to finance the losses is money going from the owners to Harmonization Limited, which they own 100% of. So you will agree that if they own 100% of it, apart from tax matters and so on, it doesn't really matter what form it goes in. Okay, the 25 million US doesn't relate to that. The destination of 25 million US is one. It's a subsidiary, which is the joint venture company that's owned by Harmonization and Tavistock. That's where the $25 million would go, and that would go in as equity. All right?
So that subsidiary, as you call it, is not currently receiving financing from the two parties that own it. It doesn't have operating expenses that it has to incur.
So what has happened over a long period of time, in a situation that we've inherited, a lot of the development work has been, my understanding is, has been put up by the operating partner, right? But that's, traveling here, traveling there, etc. Whatever. Yeah, correct. And they have their own way of accounting for that the government has to verify and so forth. But what the member from Southeast St. Andrew is alluding to is to get some of the pre-design work. The funds needed are in the order of a few million US dollars. And, my understanding is that the other shareholder would prefer if both shareholders contribute to those kinds of expenses because of the size of those expenses. But in the meantime, that company just has ownership rights to a piece of land that it hopes to develop, and there are costs associated with that. But in terms of I hope I've answered that question. Technical, okay. So the real estate will eventually be the property of the joint venture company. My understanding is that it's not vested, my understanding is that the joint venture company, has rights to the land, but those rights have not been crystallized yet at the titles office. My further understanding is that at a particular point in the process, once sufficient progress has been made, those transfers will be effected and perfected.
So who owns it currently? Who's on the title currently?
I don't want to give you the wrong answer, so let me verify, but it is one of the government entities. I have to verify which particular government entity it is. Yeah. But it's legally within government, but the rights to it essentially have been effectively transferred by virtue of the framework agreement.
Minister, I'm very much interested in this project. As was indicated, it spans a long time across administration. And this project was supposed to be a transformative investment in terms of the eyeing of the tourism industry, that it would seek to shift Jamaica from just being in the middle or lower end of the tourism market. That said, it's been as long as it has been. I have had some dealing with it in the early stages for one element of it. And so I've been tracking it to see how it has been going. In your answer to question 3, Minister, you made reference to the governance plan and the milestones that are to be agreed on between the parties. That agreement, I understand, is critical for the next stage, notwithstanding the other questions asked by the leader of the opposition further to your issue about the debt and financing those that would have been incurred. But for the project to move forward, it's to fine-tune those technical and engineering works to go to market for another phase of it. That is where the thing has been at a virtual standstill. So my question is, given the antecedents of how long it has been in gestation, are you putting some specific timelines on each phase of the activities that are to be completed so that it can move forward. And I ask that question, Minister, against the background of your earlier comment about how the project started as against what it would have been if it is now. We are either in it or we are not in it. And if we are in it, we must seek to have it executed in the shortest possible time. We would like to know, is it the government side or is it the private investor side that is creating this jam, this slowdown for it not to move to that phase?
I'm happy to see, Madam Speaker, there's a lot of interest in this project. And I look forward to your support, continued support at various avenues. A lot of progress has been made. There was a long period of time where the project couldn't move forward because the financing was not available. And for some time now, that problem has been solved. There is a capital structure that includes equity and I believe some forms of preferred equity and some forms of innovative financing, some mezzanine financing, some debt financing, a lot of it actually secured from institutions right here in Jamaica. So the financing aspect of it is quite secure. How this project was originally structured, one of the features of it that, as I said, we would never structure a project in this way today, is that it carries inherent fiscal risk, significant fiscal risk. And there are features in a joint venture agreement that are subject to interpretation, no doubt, but one interpretation, which has a good deal of support, is that the joint venture partner, there are conditions under which the joint venture partner can initiate proceedings that would result in the government of Jamaica having to fork out lots of resources. Okay, that I will. So one of the things of the governance is that we want to, the idea is that you want to get to a certain place in terms of progress, and one of what the government would want is that after a certain time, that what we call a hammer goes away. Okay, because we are not prepared to have that as a contingent liability, when we talk about the governance arrangements, we mean that and other things. So the parties are in negotiations, and progress is being made. It is my belief that once we're able to table the LPPIA and have it passed, shortly thereafter, in fact, this project might be the first project to benefit. So the tax concessions are initially conceived, if you want me to go into details, were done in the way we did things in a non-transparent way, right? Something done in the Gazette, this percentage, that percentage, that percentage. Now, while we want to honor the spirit of it, we want to do it in a way that that anybody who meets certain criteria can get similar benefits. The Harmony Cove project will always be an exception because its benefits are sweeping. But what we want to, you see, one of the risks, if we do it the way it was done before, then the line will be long for people saying, hey, they got it, what about me? Okay? And that can create the kind of leakage that can undermine Jamaica's fiscal sustainability. So what we intend to do is, with the LPPIA, we'll have a transparent mechanism by which mega projects that meet predetermined criteria, a rules-based system with where the application of discretion is much more limited than has been the case when we did these things in the past, and that is transparent, that everybody can see this is what the project is getting, the project meets these criteria. That is the framework in which we want to make progress on this. As I said, because it's a project that, the benefits were conceived a long time ago, It won't fit necessarily squarely into this framework that we're creating, but it will be close enough so that to the extent that there are people that say, hey, I'm also doing that. I say, well, look, you meet this criteria, you invest $1 billion or more, you hire over X thousand number of people with all of these other conditions, then you too can benefit from certain concessions without cap on the amount of such concessions that can be outstanding at any one point in time.
A little difficult. The latter points you made, Minister, which I can appreciate going forward. We have an existing agreement in place between two distinct parties. And in the contractor arrangements, I presume it will be clearly set out the benefits that will accrue to either party. 1. 2, if either party should want to exit the agreement, what the provisions are for doing that. So those are already in place. What you are enunciating is in regard to similar arrangements like these going forward, but I don't presume that they could be retroactive to erase the previous agreements. So that being said, all of that would not be so relevant to the particular Harmony Cove situation with a clear set of terms of agreements. So could you just clarify that in my mind, that it's the distinctness of both?
It's a little more complicated, member, because there are time frame issues. When the thing was initially gazetted, there were time frames and so forth. So and a lot of time has passed. So it's a little more complicated than that. What we'll be seeking to do is to replicate the spirit of that agreement, but to replicate it within, or to implement it within parameters that will not lead to negative contagion in terms of fiscal sustainability. Yeah.
No, are we finished with this one? Madam Speaker, there is one of the three questions standing in my name. One is a carryover, right? When the time had expired, so the minister would have had the answers prepared if he was obedient to the provisions of the standing order. It would appear that there is some disobedience to the standing order. Hence the extended delay in answering that first set of questions, separate from the latter two which I tabled. So, my minister, you generally sought to be an obedient minister and member. So if you don't have them this week, I trust next week you'll have them ready. At least questions.
If you'll indulge me, Madam Speaker, the member very fondly reminds me that I have questions to answer that he has tabled. I've had opportunity to speak with him outside of these hallowed halls, and I have communicated with him that I intend to answer the questions from the member of Southeast St. Andrew first. I am very aware that this House doesn't exist solely for the Minister of Finance to occupy a standing position, and therefore, I have said to him that I'll answer the member of Southeast St. Andrew on one day, and then another day answer him, so that we can have all the time required to answer the questions. And you'll see the spirit with which I answer the following questions here, because there's no rush. Time has been allocated. So, member, I assure you that in due course your questions will be answered. I happen to have an engagement next week, Tuesday. I won't be here to answer them, but I assure you that the Tuesday following, I will be here to answer your questions and any other related to that you may have. Okay?
Speaker, I do accept the minister's undertaking for the following week. But because the minister always speaks about being able to multitask, I thought that he would be able to answer all of them the same day. But I will humbly wait until the week after.
Member, you don't have any option but to yield after that impassioned and very well prepared.
Madam Speaker, I sought to intervene and to rescue the minister, because my understanding is that after these after the sectoral debates, that there will be an opportunity for a number of questions in the standing orders to be addressed. So I am looking forward to it. The member opposite, we have discussed it, and we are looking forward to a period of answers to questions.
Thank you very much. And I'm forced to say that the leader of opposition business always has an approach that I want to think sets him apart. Thank you very much. Yes. He knows that's exactly how I feel. You can ask him. Oh, yes. Motions that may be made at the commencement of public business requiring notice, motions relating to sittings of the House, motions for leave to introduce bills, presentation of bills without leave of the House, first obtained, and now we're back to public business.
Madam Speaker, on public business, the Minister of Finance will now take the measure in relation to the Jamaica Development Bank Repeal Act 2020. May it please you, Madam Speaker.
Madam Speaker, I rise to debate the bill, or to open the debate on the bill, and act to provide for the transfer of the assets of the Jamaica Development Bank to the Bank of Jamaica Limited, and to repeal the Jamaica Development Bank Act and for connected matters, cited as the Jamaica Development Bank Repeal Act 2021 for the consideration of this House. Madam Speaker, this bill seeks to repeal the Jamaica Development Bank Act and provide for, among other matters, the transfer of all assets of the Jamaica Development Bank to the Development Bank of Jamaica in exchange for the issuance of shares in the DBJ to the Accountant General. 2, transfer of the liabilities of the Jamaica Development Bank to the Government of Jamaica. 3, transfer of the functions performed by the Board of Directors of the Jamaica Development Bank to the Board of the Development Bank of Jamaica Limited. And 4, to exemption of transfer tax and stamp duty that would otherwise be applicable to the transfer and disposal of assets by the DBJ. The Development Bank of Jamaica Limited, Madam Speaker, was created in April 2000 from the merger of the National Development Bank Limited and the Agricultural Development Credit Bank. Consequent on this merger, Madam Speaker, the affairs of the Jamaica Development Bank became the purview of the Development Bank of Jamaica. The bill before this Honourable House now seeks to complete the dissolution process. Madam Speaker, let me just take the House through the clauses of the bill. Clause 1 cites the name of the Jamaica Development Bank Repeal Act and informs that the bill would come into effect on a date to be appointed by the Minister by notice published in the Gazette. Madam Speaker, Clause 2 provides a general interpretation for the words assets, appointed day, liability, and right as used throughout the bill. The repeal of the Act is expressly provided for in Clause 3. Clause 4 makes provisions for the treatment of the assets and liabilities of the JDB, including 1. On the appointed day, the transfer of all monies held in any bank account in the name of or standing to the credit of the JDB into the consolidated fund, and the JDB shall then be closed. And 2. On and after the appointed day, A. The rights and assets vested in the JDB shall vest in the DBJ. The liabilities of the JDB shall be the liabilities of the Government of Jamaica. In exchange for the transfer of the rights and assets of the JDB to the DBJ shall issue shares in the DBJ to the Accountant General equal to the value of the assets remaining as at the appointed day. And D. All records and data of the JDB pass to the DBJ. Madam Speaker, Clause 5 outlines how agreements, instruments, and other documents which refer to the JDB are to be treated. That is, any reference to the JDB in any agreement, instrument, or document is to be read as if it were in reference to the DBJ, and any reference to the Board of Directors of the JDB in any such agreement, instrument, or document is to be substituted with the Board of the DBJ. Pursuant to Clause 6, transfer tax and stamp duty that would otherwise be applicable to the transfer and disposal of the assets by the DBJ will not apply to the transfer and disposal of the assets under the Act. Clause 7 expressly provides that the functions of the Board of Directors of the JDB will be performed by the Board of the DBJ. Madam Speaker, the final clause, Clause 8, seeks to preserve any existing right, privilege, obligation, or liability in relation to any contractual obligations existing under the Act. The Memorandum of Objects and Understanding gives a general statement of the purpose of the bill. Madam Speaker, I now invite members of this Honourable House to support the passage of the Jamaica Development Bank Repeal Act 2021.
Madam Speaker, we have no objection to what is being proposed.
Madam Speaker, I ask now for a second reading of the bill.
Those in favour? Those against? The ayes have it.
A bill entitled An Act to Provide for the Transfer of the Assets of the Jamaica Development Bank to the Development Bank of Jamaica Limited and to repeal the Jamaica Development Bank and for connected matters read a second time.
The House will now resolve itself into a committee of the whole House to consider the bill clause by clause. Members, I now put clause 1. Those in favour? Those against? I now put clause 2. Those in favour? Those against? The ayes have it. I put clause 3. Those in favour? Those against? The ayes have it. I put clause 4. Those in favour? Those against? The ayes have it. I put clause 5. Those in favour? Those against? The ayes have it. I put clause 6. Those in favour? Those against? The ayes have it. I put clause 7. Those in favour? Those against? The ayes have it. I put clause 8. Those in favour? Those against? The ayes have it. I now put the title and in the enacting clause. Those in favour? Those against? The ayes have it. Members, the question is that I do report the bill as having passed committee stage with no amendments. Those in favour? Those against? The ayes have it.
Madam Speaker, I now ask that the bill be read a third time.
The question is, members, that the bill be read a third time. Those in favour? Those against? The ayes have it.
A bill entitled An Act to Provide for the Transfer of the Assets of the Jamaica Development Bank to the Development Bank of Jamaica Limited and to repeal the Jamaica Development Bank Act and for connected matters read a third time and passed.
Madam Speaker, just like to report to the Honourable House that there will be a minor change in terms of the program plan for tomorrow in respect to the closing of the sectoral debate, in that it is customary that in closing we do reference presentations in relation to the completion of the debate to that point. And given that the member from St. Catharines Central and Minister of Gender Affairs, among other subjects, will speak tomorrow, I've opted to close the debate on Tuesday the 14th so as to capture the essence of the presentation of all members. Bearing in mind that the honourable member from Southeast has the right for sotto voce, which we do appreciate. We will not respond to let him know that this is a new dispensation of management and we treat things with more efficiencies than he's accustomed to. Madam Speaker, it is not intended to do any further business for the day, so I invite you to adjourn this Honourable House until tomorrow, June the 9th, the 8th, I'm sorry, June the 8th at 2 p.m. at the George William Gordon House. May it please you, Madam Speaker.
Members, the question before the House is that we do adjourn until tomorrow, the 8th of June. And I want to emphasize to the members, the Parliament starts at 2 p.m. If we want to finish on time, we need to obey and be here for 2 p.m. tomorrow, the 8th of June. Everybody, I know sometimes I'm talking to the converted, but I ask you to pass it on to those who have not yet been converted. Parliament starts tomorrow, the 8th of June at 2 p.m. Thank you. This House, Honourable House, is now adjourned.